trial. He was found guilty by a judge for two different incidents. The most serious of them was in December of 2022 when he was found guilty of shooting and killing 50-year-old Anthony Wynn at a Cleveland gas station. This happened at the Shell on the corner of St. Clair Avenue and East 100th Street. It's a gas station as well as a little deli. According to police, there was an altercation at the gas pumps when Buchanan Jr. pulled out a gun and shot Anthony Wynn. Wynn would later die at the hospital. Now, the second incident involving Mr. Buchanan was a month earlier at a commercial complex on West 117th Street in Cleveland, and that was also a non-fatal shooting. So in a 2-month period, he was involved in two different shootings, one that killed a man. It was the request of Mr. Buchanan through his attorneys to not go to a jury trial, but instead to have the judge decide his fate in this, and that was the Cuyahoga County Court of Common Pleas Judge John Satula. We have the all rise. Remember, this is a sentencing. We could hear family members of Anthony Wynn giving their victim impact statement, and there could be some details that are a little hard to hear about the murder of Anthony Wynn. Let's take you live into court.
Two misdemeanors to the right there.
Right, okay.
And this is the main one over here with the case laws. Here's the police chief for the mergers.
All right, we're here with the case of the state of Ohio versus Bobby Buchanan. We're here in a sentencing hearing in 3 cases. And we're going to go in descending order. In case number 689514, on a previous day in court, the defendant pled guilty to attempted harassment by an inmate with a bodily substance. That's a misdemeanor of the 1st degree. That's punishable by time of incarceration in county jail of up to 180 days and or a fine of up to $1,000. In case number 684330, the defendant pled guilty to attempted assault in violation of Revised Code Section 2923.02 and 2903.13, a misdemeanor of the 1st degree. It again is punishable by time of incarceration in county jail of up to 180 days and or a fine of up to $1,000. In case number 676647, the defendant, after a bench trial, was found guilty of aggravated murder with a 1 and 3 year firearm specification in violation of Revised Code Section 2903.01. That's an unclassified felony. That's punishable by time of incarceration in prison for life without possibility of parole of 20 years, 25 years, 30 years, or life without the possibility of parole. The 3-year firearm specifications must be served prior to and consecutive with the underlying sentence, effectively making it 23 years, 28 years, 33 years, or life without the possibility of parole. He was also convicted of murder in counts 2 and 3 in violation of Revised Code Section 2903.02A and 2B. And he's also convicted of felonious assault in violation of Revised Code Section 29 03.11A1 and then A2 and 4 and 5 respectively. These counts all merge into the aggravated murder charge. However, the firearm specifications remain, the 1 and 3 year firearm specifications remain. The defendant also was found guilty of having a weapons under disability in counts 6 and 7 in violation of Revised Code Section 2923.13. That's a felony of the third degree. And counts 7 and 6 will merge, and the state elects to proceed as to count 6. Felony of the third degree is punishable by time of incarceration in prison in stated terms of 9 months, 12 months, 18 months, 24 months, 30 months, or 36 months, and or a fine of up to $10,000. He also was found guilty of failure to comply with an order or signal of a peace officer in violation of Revised Code Section 2921.331B. That's a felony of the third degree, again punishable by time of incarceration in prison in stated terms of 9 months, 12 months, 18 months, 24 months, 30 months, or 36 months, and or a fine of up to $10,000. If the court imposes a prison term on any other count and this count must run consecutive to the other counts. There's also 6 points on his driver's license and a Class 2 3-year to life driver's license suspension. The defendant was also found guilty of attempted murder in violation of Revised Code Section 2903.02 and 29 23.02. That's a felony of the first degree. It also has 1 and 3 year firearm specifications. A felony of the first degree is punishable by time of incarceration in prison in annual increments of between 3 and 11 years inclusive, which will be referred to as the minimum term, and or a fine of up to $20,000. Now, this is the most serious offense for which a prison term could be imposed. And as a result, is subject to the Reagan-Tokes Law. The Reagan-Tokes Law is an effort by the legislature to encourage defendants who are sentenced to prison to come out as a better person than when they went in. And the way the laws set up, it's the way they do that is they hold over the head of the defendant an extended sentence. That extended sentence is 1/2 of any sentence the court imposes of between 3 and 11 years. So if the court imposes a 3-year minimum sentence, the extended sentence is 1.5 years, and the maximum sentence is 4.5 years. If the court imposes 6 years as the minimum sentence, the extended sentence is 3 years, and the maximum sentence is 9 years. If the court imposes 11 years as the minimum sentence, the extended sentence is 5.5 years, and the maximum sentence is 16.5 years. Now, any firearm specification must run prior to the start of any minimum sentence. Now, since this is an effort by the legislature to encourage defendants to go to prison to come out as a better person, if the defendant in fact does that, then there's no need to impose that extended sentence. If, however, the Department of Corrections believes that the defendant has failed to live up to their expectations of his behavior, what they have told him from the beginning, then they have to go to an administrative hearing and demonstrate why the defendant has failed to meet its expectations and seek permission to impose that extended sentence. If the administrative hearing agrees with the Department of Corrections, then they can then hold the defendant until the end of the maximum term. So to put it a little bit differently and a little bit more legalese, there is a rebuttable presumption of release at the end of the minimum term by the Department of Corrections. The Department of Corrections is authorized to continue the incarceration to the end of the maximum term if the presumption is rebutted at an administrative hearing. The Department of Corrections is to set rules and criteria for it to rebut the presumption of release as to a specific determination as to the defendant's conduct. At the end of the maximum term, the defendant must be released. Any mandatory term or term for all specifications must be served prior to the start of the minimum term. Now there's another provision here that affects qualifying felonies for Reagan Topes, and that is the Department of Corrections may request an earned reduction of minimum prison term credit if it chooses to do so between 5 and 15% of the minimum term for exceptional conduct or adjustment to prison. If requested, it is presumed that the credit will be given unless the trial court overrules the Department of Corrections and denies the credit. This applies to the minimum term to 3 to 11 years that the court can impose. And if the Department of Corrections wants to give the credit, it can do so only subject to the Court of Appeals saying, not the Court of Appeals, but the trial court saying, no, you can't. The defendant was also found guilty of counts 9 and 10. These are 9, 10, and 11. These are felonious assault charges, each in violation of Revised Code Section 2903.02 with 1 and 3 year firearm specifications. I'm sorry, it's 10 and 11. 9 is the attempted murder. 10 and 11, these merge with the attempted murder in count 9. And although these are would be qualifying felonies, because there is a felony of the first degree here, that takes precedence over the felonies of the second degree. However, the firearm specifications survive the merger into count 1 or count 9. He also was found guilty of having weapons under disability in violation of Revised Code Section 2923.13, a felony of the third degree in each of these two counts. Counts 13 and 14 merges, and the state elects to proceed for count 13. That's a felony of the third degree, punishable by time of incarceration in prison in stated terms of 9 months, 12 months, 18 months, 24 months, 30 months, or 36 months, and or a fine of up to $10,000. Now, there is a life term here present, but one of the discussions we've been having prior to coming out here on the bench is the effect of the firearm specifications. There's been recent case law from the Court of Appeals and the Supreme Court concerning how the trial court is to handle sentencing for gun specifications in various cases and in various incidents given rise to penalty, and whether or not these firearm specifications must be merged or run concurrent with each other or run consecutively. We'll hear from Mr. McNair for the state on that first.
Judge, I know we had a more detailed discussion in chambers and without going through all the statutes and applicable cases. Our position is that there are 8 firearm specifications available to you, 8 3-year firearm specifications. You can, at your discretion, run all 8 of those specifications consecutively for a total of 24 years of firearm specification time. Falling short of that, you are required to run at least 2 of those specifications consecutively to each other for each incident. So you must run 2 of the 3-year specifications consecutively to each other and to any other sentence for the November felonious assault, shooting, and attempted murder. And then you must also run 2 3-year specifications consecutively on the December 2022 murder. And those specs have to be consecutive to each other and to any other sentence. So it is a minimum of 12 years of specifications and a maximum of 24.
All right. Ms. Rocco?
Thank you, Your Honor. Your Honor, we would agree with the prosecution that it is in your discretion to run them consecutive, but we disagree as to the mandatory minimum gun specifications. Your Honor, we would point to the plain language of statute 2929.14, B1G. It says if the offender is convicted or pleads guilty to 2 or more felonies, and if 1 or more of those felonies are aggravated murder, attempted aggravated murder, attempted murder, aggravated robbery, felonious assault, or rape, and the offender pleads guilty or is convicted of a specification of the type described in Division B1A in connection with 2 or more felonies, the sentencing court shall impose on the offender the prison term specified under B1A of the section for the 2 most serious specifications. I think the plain language reading of that is that you are required to run the 3 years consecutive, meaning that it has 6 years of mandatory specifications instead of 12. Thank you, Your Honor.
All right, thank you. Mr. McNair, any rebuttal?
Judge, that ignores the other statutes that also control firearm specifications. B1G deals with firearm specifications within a single act or transaction. When you have multiple acts or transactions, criminals are not entitled to a bulk discount on firearm specifications merely for extending their malfeasance in an ongoing felonious extravaganza.
All right, the range of sentences then here are with a potential of 24 years of firearms specifications. It could range up to 30 years and 9 months, up to 49 and 5 months, or 6 months rather, together with the murder, aggravated murder, which is 20 years, 25 years, 30 years, or life without the possibility of parole. There's also potential fines of $75,000. Prior to coming out of the bench today, I had the opportunity to review the entire case file, the pre-sentence investigation report, revised code sections 29, 29.11 for the principles and purposes of sentencing, revised code section 29, 29.12 for the seriousness and recidivism factors, and revised code section 29, 29.13 and other revised code sections for felony sentencing of unclassified felonies, felonies of the first degree, third degree, and revised code section 29, 29.21 for misdemeanor sentencing. I also had the opportunity to review the entire case file, the pre-sentence investigation, as I said, also the letters in support of the victims here, and various case law related to sentencing with firearm specifications, which we discussed with counsel in chambers. Present is Mr. Buchanan, along with his counsel, Linda Herico, Henry Hilo, and Charles Koselka. Representing the interests of the state are Assistant County Prosecutors Ben McNair and John Saline. Mr. McNair?
Yes, Your Honor. Detective Daniel Lentz from the Cleveland Division of Police Homicide Unit is also here with us.
Right. Like to speak, or?
Yes, regarding sentencing?
Yes.
Yes. Judge, I'm asking you to sentence him to life without parole. Prior to the events that brings him before today, Mr. Buchanan already had an extensive criminal history. He had prior convictions for drug trafficking and attempted robbery, as well as having weapons under disability. You know from sitting through this trial that this case involved two completely unprovoked, heinous assaults on innocent citizens who were just going about their business. These were both broad daylight shootings. The attempted murder in November involved Mr. Buchanan pulling his firearm and putting it to the victim's head. It was only when that victim batted the firearm away that he was shot in the stomach. And then again, the homicide in December involved just a completely unprovoked, senseless killing of one of our own. We see that he is unable to comport himself with the rules, either of ordinary society or even while he is incarcerated. There is no daylight for him. His behavior will not improve. And you see that on the assault and harassment by inmate cases that you have before you. Even when he cannot shoot people, he will still assault them. He will still spit on COs. He is a threat who needs to be removed from society. The court has received letters from the decedent's family, and there are, I believe, two family members here who also wish to address the court. Michael Williams' brother and Kayla Williams' daughter. The court already has a spelling in their names.
Morning. Good afternoon. Okay. All right. My name is Michael Wynn. Okay. Good afternoon, Your Honor. My name is Michael Wynn. I'm the older brother of Anthony Lamar Wynn Sr. First of all, I want to thank God for my family and all that love Tony. And we're thanking God to be at the end of this long journey. I am convinced that God has had his hand on this case since the death of my brother Tony. It was a tragic death, but I'm sure it served to save someone else's family from suffering the loss that our family has suffered from the action of Mr. Buchanan. I stand here today representing the Wynn Hearn family, all of Tony's friends, my mother, Mrs. Theodia Hearn, and Anthony Lamar Wynn Sr., that didn't get a chance to testify in court. 3 weeks prior to the death of my brother, Mr. Buchanan decided to shoot someone else. But by the grace of God, that victim survived. Mental illness is prevalent in today's society, but it's not a license to kill. I do not know which part of the system failed Mr. Buchanan, but I do know that it affected our lives. We as a society cannot allow individuals that have been aided in the past hide behind the legal system and cause the death of another human being. The power to end life is in the hands of God, not ours. As a result of my brother's untimely death, I am screaming murder, murder, murder. Still hard to believe that Tony is not here with us. A 93-year-old mother has lost her youngest son. She will never be the same. His children has lost their father. They are scarred for life. Siblings have lost a brother. Families have lost a member. The community has lost a dear friend. We are all in disbelief that this is our reality. It is the unbelief in God that sends people to hell. And it's a disrespect of the laws of the land that gives a person the thought that they can commit murder without consequences. We are thankful to the officers that got Mr. Buchanan off of the city streets. The family and friends of Tony won't be held hostage by a senseless act and believe that the consequences behind this murder is in the hands of God and the laws of the land. We are putting our trust in both. We are grounded in faith that God will see to it that justice will stand firm and serve a just sentence for the actions that caused the death of Anthony Lamar Wynn Sr. Since December 3rd of 2022, we have lived in grief. We now journey without Tony. Each one of us affected according to our love and relationship with Tony. We have only memories that will never measure up to our loss. We journey with the hope that no one else will suffer from the actions of Mr. Buchanan. Our hearts look to justice so that the loss of the spirit we know as Tony can rest assured that his death is not in vain. We are seeking justice because our sentence of death without notice was carried out by Mr. Buchanan by the senseless act of gun violence. We are asking you to grant him no more chances to harm or cause death to anyone else. We are seeking you send a clear message to anyone using a gun to kill senselessly that the laws of the land stand firm and is in line with the commandment, thou shalt not kill. Thank you.
Thank you.
Okay, good afternoon, Your Honor. Well, I'm Michaela Wynn. I'm Anthony's daughter. And I'm standing here today to make sure that justice is being served. I'm here today to make sure justice is being served for my father's murder on behalf of his family, children, and friends, and his mom. My father, he wasn't perfect, but he never deserved being murdered. Every day for the last 2 years, I ask myself, wonder why. If you had some kind of reason to take our father away, hope maybe I would understand in some way, but your selfish actions caused me a lifetime of pain in many ways. I had to bury my father and plan his funeral. I had to bury my father and plan his funeral at the same time. I should have been celebrating my 18th birthday with him. I had to go to therapy now because of the actions of Mr. Buchanan. I can never be genuinely happy in the life I'm living. I now hate to see girls with their dads or to hear anyone speak of their dad because you took mine away. You never thought about how it would make anyone feel. You took 2 people from their father, and I would never wish that on anyone, and not even the family of yours. The pain you make me question our Father above because you took someone with such a beautiful soul, so much ambition and love. If my father could have lived, he may have possibly forgave you. It may have shown you more mercy than I can. I'm sorry. Because he was just so compassionate for everyone. The pain you caused me and my family is so unbearable. How could you ever just end someone's life so selfishly, especially a man who did not know you at all and never came to harm his way of you? I understand that it was not your intention, but because of your decision, I've sat and I've contemplated my own life and my purpose because of your decisions. I haven't been the same, Your Honor, since December 3rd, 2022. At 5:38 p.m., you took my father, and today I leave my pain, my anger, and my confusion with you. It now belongs to you. My family, and I believe that this man deserves more time, Your Honor. I just don't want him to have another chance to harm or make anyone else's family feel the pain that my family and I feel and that we go through. Although we lost the time and cannot get it back, I'm just asking that justice be served to my father. Because he did not deserve anything that happened to him. My father was trying to change his ways and become a better person and be on a better path, but he would no longer be able to because of the decisions that Bobby Buchanan made. That is it. Thank you, Your Honor.
Don't believe yet. You asked some questions that have no answers of why this happened. There's no good reason why this happened, and keep trying to figure out a response to that. You can never come to a satisfactory answer. He doesn't have a satisfactory answer as to why this happened. Your father did nothing to generate this situation. All right, and you're how old now? 18.
Yeah, I'll be 20 on December 10th.
20? Well, you had your father for the first 18 years of your life, and you carry him in your heart for the next 50. All right? And, you have all the promise in your life that he gave you, that he raised you to carry on. And when you remember him, he wouldn't want you to shed the tear. He'd want you to smile.
Thank you.
That you had the benefit of him being your father, or your brother, or your friend and family.
Thank you.
He's to be celebrated every time. Not to be forgotten, but to be celebrated.
Thank you so much
All right.
for understanding.
All right. Good luck to you, ma'am. Mr. McNair?
Judge, I just want to thank Detective Lentz and his partners at the Cleveland Division of Police for their swift work in apprehending Mr. Buchanan. As you can see, the Lynn's are a large and loving family. They're one of the most relentlessly loving families I have ever had the privilege to work with in a homicide case. So I just thank them for their consistent faith in this process.
Ms. Ricco?
Thank you, Your Honor. Your Honor, I know that you heard the trial in this matter, that you have reviewed the extensive medical records that were given as exhibits by the defense in this case. I did want to make sure that you also have the mental health history provided through your bailiff to the court. Your Honor?
Yes.
You have that?
Yes.
Okay, thank you. We ask that all those documents be incorporated for the purposes of the record. As described in those, Mr. Buchanan suffers from a serious mental illness. He has done so for a long time. He has schizophrenia, he has delusional disorder, persecutory type with marked paranoia, and he's also been diagnosed with intellectual disability. These diagnoses have been present for over 5 years. They have resulted in numerous psychiatric hospitalizations. And despite his family and his loved ones who are here to support him today, trying to get him help, it has been unsuccessful, and they've watched his life derail. I know they send their condolences to the families of the victims. Bobby lives in a world where he misperceives reality. He lives in a world where he believes others are out to harm him, despite no reason to believe that. His mental illness was present during both of these incidents and is the cause of both of these incidents. We ask that you consider the significant mitigating factor of his serious mental illness, as well as the length of time he has been suffering it. He is a 34-year-old man. He has never been to prison before. He was previously on the mental health docket of the county police courts, and he does have a 5-year-old daughter. Any sentence that this court gives Mr. Buchanan will be a substantial one. We ask that you give him an opportunity to eventually see the parole board. When he does, at a minimum, he will be in his 60s, likely older than that. Hopefully at that point, he will be someone who has found medication that is successful to treat his mental illness. And I would put to this court that the parole board will be in the best place to determine whether Mr. Buchanan, at least 60-some years of age, will be safe to be released to the community. Your Honor, we ask pursuant to Revised Code 292903 and 2929.14B1G to impose the minimum mandatory jail sentence in this case, which we would say to the court is 26 years and 9 months to life. That would be counting a 20-to-life sentence on the aggravated murder plus a 3-year gun specification, plus 9 months on the failure to comply and an additional 3-year gun specification, and running all the other offenses concurrent. He has been in for 717 days. We ask that he be given credit for that time. That both his misdemeanor cases are statutorily required to be run concurrent. He is represented by the Public Defender's Office. He is indigent. We ask that you waive all fines, fees, and court costs, and that his mental health documentation be provided to any institution he goes to so that they can hopefully get him appropriate mental health care. We also ask that appellate counsel be assigned for him. Thank you, Your Honor.
All right, thank you. Would the defendant like to speak?
He does not want to, Your Honor.
We're going to take a short break and we'll be back.
Dan DeRosa with 19 News. As you just heard, the judge wants to take a break. This is a little bit unprecedented. We were right on the doorsteps of a sentencing for Mr. Buchanan Jr., and the judge all of a sudden needs to take a break. On the table here, you heard the state, the prosecution, has asked for life in prison with no chance for parole for Bobby Buchanan Jr. He was involved in 2 different shootings, 1 month apart from each other. His defense attorneys say that he is dealing with a mental health issue for about the last 5 years. Schizophrenia, paranoia, thinking that people are out to get him. And it was at a gas pump there at that Shell station on the corner of East 100th Street and St. Clair that for whatever reason, and we don't have a reason, you heard the judge try to console the daughter of Anthony Wynn. For whatever reason, Buchanan went over to another gas pump at that gas station and shot Anthony Wynn, 50 years old, who would later die. A very powerful statement from his daughter, 20 years old now, 18 years of age at the time, saying she should have been celebrating her 18th birthday with her father. Instead, she was planning his funeral. And that saying, my father wasn't perfect, but he didn't deserve to be murdered. The judge does have a little bit of discretion here and has a number of factors to consider. You heard them debating the gun specification. Many crimes, when you commit, if you do so with a gun, there are what are called gun specs, is what they were calling them, and it tacks on extra years to your sentence. There is a debate here about how many years should be tacked on, whether it should be 6 years or a total of 24 years. That is the judge's discretion. He had said there has been some debate recently in the appellate court about the assignment of more years based on specifications. So the judge may have to be considering that. He may also having to be tallying up because this is two different situations. In November of 2022, he shot a person who did survive. And then it was a month later in December of 22 that he shot and killed Anthony Wynn. There was also a police chase involved. You heard that there's been an incident since he has been locked up, trying to attack parole or corrections officers, spitting on them. That is another felony that he has racked up while he's been locked up. And so the question becomes, how many years? And is this someone that can be rehabilitated and put back into the public? You heard his defense attorney say that he has been in the mental health court docket for some time, but allowed to stand trial for the death of Anthony Wynn. We're going to continue to stay with this. Not sure how long that break is going to be that the judge has requested. So we will stay with this for a few minutes here, and we'll wait to see when the judge comes back in. So stay with us. Dan DeRose with 19 News here. You're watching live coverage of the sentencing of Bobby Buchanan Jr., found guilty in a slew of crimes, including two shootings a month apart from each other. The first shooting in November of 2022 did not take the life of the victim. That person survived, but it was a month later at a gas station on the corner of East 100th Street and St. Clair that an innocent man, Anthony Wynn, was simply pumping gas, and at another pump was Bobby Buchanan Jr. According to what we heard in court, there was no altercation, there was no fight, there was no words, but simply Buchanan walking over and shooting the 50-year-old Anthony Wynn, who would later die at university hospitals. Police at the time told us that Wynn was at one gas station pump, Buchanan was at a separate pump when the shooting happened, and then after that shooting, Buchanan fled. He took off and was taken into custody the next day after a police chase. We have been told early on that his mandatory minimum here would be about 32 to 33 years. But as you heard, the prosecution is asking for life with no chance of parole, saying that this is an individual who has been both violent, not only out on the street and in society, but then once locked up, has continued to be violent towards corrections officers and staff at the jail. The judge asking for a break here after hearing from family members of Anthony Wynn. We heard from his older brother, Michael, and then we heard from Michaela, his daughter, who is now 20 years old, and she had some powerful words. It was tough for her to even get through her statement to the judge, and then the judge, in a very touching moment, telling Michaela to hang on to his memory and celebrate him. The judge even saying, your dad would not want you to be shedding tears. He would want you to be smiling and celebrating him. So that's where we're at with this. We are at an abrupt break from the sentencing for Anthony Wynn. For Bobby Buchanan Jr. He is accused and found guilty of shooting and killing Anthony Wynn at that gas station, that Shell station you see there. And we are just waiting for the judge to come back for breaks. So stay with us here as we wait for Judge Satula to come back to the bench and hand out his final sentence.
No, she's good. Okay. You can bring it back out.
And we just heard the instruction given that you can bring him back out. So it looks like the judge will be back on the bench, and Bobby Buchanan will find out if he's going to get 30 years, 33 years, or if this will be a life in prison with no chance of parole type situation. There is Bobby Buchanan Jr. We took a break in the middle of sentencing.
All right, in case number
Here we go.
684-330 and 689-514, each has a misdemeanor of the first degree. Each will be sentenced to 180 days in the county jail. Sheriff will compute the credit. He'll also pay costs as they order to pay costs if he fails to do so or pay according to an approved schedule. Then the court can order him to perform up to 40 additional hours of court-teaming work service per month at the current rate of $15 an hour until such time as that judgment is paid or the default in the schedule is brought back into compliance. Each completed hour of court-teaming work service will reduce the outstanding balance. And these two counts will run concurrent with any charge or any sentence in 647. Now, in that case, as to the aggravated murder, and again, this was a completely unprovoked action resulting in the death of Mr. Nguyen, who was just pumping gas. I mean, a terrible situation for him and his family, and I can understand that even years later that the tears are still there. From everything I've seen here, that he was a good man and didn't deserve this. The sentence in the aggravated murder will be life without possibility of parole before 25 years. The 1 and 3 year firearm specifications will merge into a 3-year firearm specification to be served prior to and consecutive with that sentence. That means that the sentence would be life without possibility of parole for before 28 years. Furthermore, the count 4 firearm 3-year firearm specifications, the 1 and 3 year firearm specifications, those two are merged with each other. And the 3-year firearm specification would be consecutive to the underlying, the other offenses, so that the sentence would be 31 years before possibility of parole, life without possibility of parole before 4 years. Counts, the firearm specifications in counts 3 and 5 run concurrent with this case, or with the aggravated murder. Now, count 6 is a felony of the 3rd degree. The defendant would be sentenced to 36 months of in prison. That'll run concurrent to count 1. count 7 runs concurrent, count 7 merges into count 6. Count 8 is a felony of the 3rd degree. That's a failure to comply with an order or signal of a peace officer. The defendant will be sentenced to 36 months on that count. That runs consecutive to any, prior to and consecutive with any sentence on the aggravated murder, so that in effect the sentence would be 34 years before possibility of parole for a life sentence. As to count 9, qualifying felony of the 1st degree, this is the assault on at the Giant Eagle store. The defendant will be sentenced to 8 years as a minimum term, plus 4 years as extended term, 12 years maximum term, plus the 3-year firearm specification, which merged with a 1-year firearm specification and must be served prior to and consecutive with the 8 years minimum term before the start of the minimum term. So that's 11 to 15 years on that count. And then count 11 will merge into count 9, as well as count 10, but the 3-year firearm specification for count 11 will be prior to and consecutive with the count 9. So effectively, this is 14 to 18 years in prison on this count. However, the underlying sentence for count 9, the 8-year minimum term up to 12 years, will run concurrent with the aggravated murder. But the 3-year firearm specifications for count 9 and count 11 run consecutive to the time set forth in count 1 and count 6, effectively making count or the sentence to be 40 years in prison before possibility of parole, life without the possibility of parole before 40 full years. As to count 13, count 14 merges into count 13, the felony of the 3rd degree. That's 30 months. That'll run concurrent with count any other count here. Count 1, he's subject to old style parole. Count 6 and count 13 and count 8 are all felonies of the 3rd degree. And he's subject to post-release control for up to 2 years at the discretion of the Adult Parole Authority. For count 9, the qualifying felony, it's a mandatory minimum of 2 years of post-release control up to a maximum of 5 years. If the defendant were to fail to meet the terms and conditions of any post-release control supervision imposed upon him, then the Adult Parole Authority can modify and or extend the supervision and make it more restrictive, incarcerate him for up to 1/2 the original term imposed by the court, charge him with a new offense called escape, another felony where he would face additional prison time, and if he were to commit a new crime while under the post-release control, he could face the maximum penalties under the law for the new crime committed, plus a prison term of the greater of 1 year or the remaining time on the post-release control, which must run consecutive to any new time that he receives. Now, he may be eligible for earned days of credit under the circumstances specified in Revised Code Section 2967.193. To earn the credit, it's not automatic. He may do so by productive participation in educational, vocational, or substance abuse treatment programs, or prison industrial employment for up to 8% of the stated term. He's also ordered to pay costs. As they order him to pay costs, if he fails to do so or pay according to an approved schedule, then the court can order him to perform up to 40 additional hours of court community work service per month at the current rate of $15 an hour until such time as that judgment is paid or the default of the schedule is brought back into compliance. Each completed hour of court community work service will reduce the outstanding balance, and the hourly rate could change. He's also entitled to 716 days of jail credit. Mr. McNeil and Mr. Rico, is there any issue with the sentences I've laid out here?
No, Your Honor.
Judge, just to be clear, your total aggregate sentence is 46 to life?
40 to life.
40. I have 25 years to life on the aggravated murder, plus the 3-year firearm specification. The 3-year firearm specification on count 4. The other firearm specifications merge. Count 8, which is the failure to comply, 36 months, that runs consecutive by law. Is the count 9, felony of the first degree, 8 years up to plus 4 years extended term, 12 years, plus a 3-year firearm specification, plus a 3-year firearm specification from count 11, which merges into count 9, as well as count 10.
Okay, I'm tracking that. I see.
Pardon me?
I see how you did the math.
Is the math correct?
Yes, I just, when you read through it the first time, it must have not been as clear to me as it is now. Thank you.
All right. Since this was a trial, he's entitled to appellate rights. That if the defendant is unable to pay the cost of an appeal, the defendant has the right to appeal without payment. And if unable to obtain counsel, counsel be appointed without cost. If unable to pay document costs of appeal, the same will be provided without cost. The defendant has the right to have a notice of appeal timely filed on his behalf. Upon the defendant's request, the court shall appoint counsel for the purposes of appeal. Mr. Rico, what's the pleasure of the defendant?
Your Honor, we are requesting appellate counsel be appointed. I know that I have spoke previously with, we asked that it not be the public defender's office to not
Right.
include him for making any claims. I have spoke with both Tim Sweeney and Russ Bensing, who would be willing to take it if this
Right.
court was so
The
inclined.
court will appoint Kevin Cafferkey as appellate counsel, transcript to be at state's expense. Anything else?
No, Your Honor.
Mr. Rico, anything?
No, Your Honor.
Did I comply with all the obligations under Criminal Rule 11 and Reagan Tokes?
I don't know if you have, did you put a license suspension on the record?
Pardon?
I know you advised him of the license suspension. I think you have to sentence him on it.
Oh, that's correct. He does have a driver's license suspension on count 8. That'll be class 2, lifetime suspension. And there's 6 points on his driver's license. Anything further?
Nothing, Your Honor.
Mr. Milo?
No, sir.
All right.
Thank you.
Thank you. This is remanded.
You've just watched the sentencing of Bobby Buchanan Jr., accused and convicted of a heinous murder where he completely shot an unsuspecting man.
I'll say one other thing for the family of Mr. Wynn. You know, my sentence here does not place a value on his life. You know, I have certain constraints and everything, and whatever I do to Mr. Buchanan doesn't reflect, Mr. Wynn's life, how much you loved him and everything. It has no bearing on that whatsoever. It's not how I value his life whatsoever. I have to fashion what the court considers a fair sentence, and this sentence, I think, make sure that Mr. Buchanan can't do any harm to anybody for a long, long time, all right? And allow you to lead your lives without worry about him coming out, all right? Thank you.
The judge with some final words there for the family of Anthony Wynn, who was simply pumping gas when Bobby Buchanan Jr., according to his defense attorney, was just simply paranoid and then shot Mr. Anthony Wynn at that gas pump. He would later die at University Hospitals, given his first chance of parole at 40 years. So a minimum of 40 years in prison, given life, and he will have to seek a parole board and ask for early release at 40 years. But that'll be up to the parole board at the time. He's, I believe they said, in his 30s, so he's looking at somewhere in his 70s he'll be able to ask for parole for the first time. We'll have a complete wrap-up of today's hearings on our early newscast when we start at 3 o'clock on Channel 19. If we have anything else breaking news, it'll be right here on our digital platforms. Until then, I'm Dan DeRose with 19 News. Have a good day.
19 News is everywhere. Download our CTV apps and follow us on social media at Cleveland 19 News.